And welcome to week number 4 of J150, Introduction to Criminal Law. And you'll look in the background to see a new background from your other recordings, week 4 and earlier. It's because I have moved. So I've been really busy for the last few weeks getting ready to move into another location, be completed by May 1st. So sometimes your grading might be a little slower, though I've kind of been trying to keep close to keeping you guys up to date. So let's go ahead and let's get started. I'm going to share my screen. And that's not what I want to share. That's what I want to share. Okay, so anyway, let's start out by taking a look at instructor information, which you have. And you're familiar with the times you can reach me, your library resources, and all of these tabs here. Reminding you that our lectures are every other Tuesday, 8:30 to roughly 10 o'clock. And after today, we'll have just 3 more lectures to go. Okay. So then, I've already told you about the helpful resources. So let's go right into our week 4 announcement. Let me reconnect this. I don't know why I'm having trouble here with this. Give me a minute. Okay, that should take care of that. So anyway, our week 4 announcement starts out with announcing Module 4, Crimes Against People and Property. And then your reading was 7 and 8 of Criminal Law and Procedure, Shive and Shive. I did send you the PowerPoints and the additional information or outlines. And then we're going to go over crimes against people and property. Then, as of tonight, 11:59 p.m. Central Standard Time, your initial post is due, robbery, burglary, and theft. And I've judged from some of you guys got kind of tricked with some of this, and we're going to talk about this a little bit tonight. And then, of course, your reply post is due Saturday, 11:59 p.m. Central Standard Time. Finally, your written assignment involved rape shield laws. Remember the requirement. It's 2 pages. And remember that it is going to be a requirement of citations in the body and references at the end. And then I recommend running your papers through Grammarly and including a lot of critical thinking in your papers. We want to see your thoughts on what's involved here with this particular issue after you conduct your research, and remind you again that using the textbook alone will cost you 2 points. If you, let me scroll back up, you'll see it right here in the reminder. So you'll lose 2 points right off the bat. Then I also remind you about the APA requirements. So when you write your papers, and then you have the quiz, which I recommend that you take on Sundays, but some of you guys like to take it earlier. It's a time quiz, 10 questions, 1 minute average for each question. And then we want you to complete the mid-quarter student survey. If you could complete that, and I take a look at those, I read those to see what concerns or issues that you might have, things that could help you more. Though I, again, try to make myself available as much as possible to you guys. So you know that already. So, okay. So then again, my motto is reflected here as well as normally. So now let's get to our course calendar. Let's get to it. Here we go. Again, the course calendar, as I encourage you to look at, it tells you again what the assignments are and everything that's involved. You see the reading assignment for this week, your initial post, today's lecture, your reply post, and then the assignments that I just went over with you a few minutes ago as well. Okay, so then your next lecture again will take place on the 25th. The 25th of, I'm sorry, no, that's this one now. The next one won't be until May. That'll be May 9th, I believe it is. Yeah. So this will be the last one for this month. Okay. So now let's go on and let's look at the module 4. Let's look at the actual assignment. Again, repeating, and the scenario here, and it gives you the information. And notice the requirements, 2 to 3 pages. Now, I've also, again, I remind you, I've given you a rubric to help you, to guide you along. I don't repost it every week because I provide it at the beginning of the course, and this is what it looks like. This is it right here. And I sent you the email, and I told you if you take a look at your discussion rubric, written assignments, and then course project. And notice that your written assignment rubric, here it is right here again, and it tells you what to expect in terms of points for each week. So here is week 3 that we had. So now you're in week 4. Week 4, here we go. And it tells you what the requirements are. 2 to 3 pages in length. Cost you 1 point. Describe rape shield laws and state why various states have enacted rape shield laws. Explain how the court determines if such testimony is allowed and if it must be completed in an in-camera hearing. I'll be talking about that a little bit tonight. Also, define an in-camera hearing. Explain what it is. Provide your sources that you use to discover the information. Explain if the court should allow the defendant to offer testimony of the victim's sexual activity, including whys and why not. So, I'm going to be reading that in there. And then APA requirements are 3 points. 3 points. Okay? APA requirements. No spelling or grammatical errors is 1 point. Okay? And that totals 20 points. 5, 10, 15, 16, 17, and 3 is 20. And that's the rubric that I gave you. Okay? So make sure that you follow that as well. Okay? So now let's get out of this. Okay. Let's get out of. Okay, now we go back. Okay, I don't want to go to that. I always have a problem whenever I use this particular mode. Okay, so now let's go back to sharing the screen. Okay, I want to get out of that. Oh, I know how to do that. back in the classroom. And so let's go back to this. That's why I hate using this one. I like using Firefox. Okay, so now we got that. So let's go back to this. And then let's share the screen. There we go. So now we're back. I gotta log into the classroom. Here we go. Okay, so anyway, let's go back to Module 4. And so back to the assignments. Here we go. So anyway, this is where we were and I lost here. So anyway, the point of the matter is make sure that you satisfy all the requirements here that I've stated over and over, and it tells you the same kind of questions that were offered in your rubric as a check sheet. Then your discussion post, and then, of course, your quiz. Okay? So now let's go into the lesson content. So we're going to discuss, as I said earlier, crimes against property, people, and we're going to deal with the issue of theft. I just killed a bug there. Okay. Here's again your assignments, 7 and 8. We're going to talk about that in a minute. Your written assignment, your discussion, your quiz, and then please do the mid-quarter student survey. Very important. And then this crimes against people and property, it defines assault and battery. We're going to talk about that. Rape and sexual battery, larceny, commonly called theft today. False pretenses, which you won't deal with a lot of. Burglary versus robbery, we're going to talk about that. And then there's a little exercise that we ask you to do by drag and drop. So I'm just going to do a couple. It says the unlawful use of force by one person against another that entails some injury or offensive touching. The willful and malicious destruction of any real or personal property belonging to another. The breaking and entering of a dwelling with the intent to commit a crime, therein included but not limited to theft, assault, while someone is present within the dwelling. While someone is present. Now, a lot of people would go for this, but I know it's going to kick it out because that's not it. It's this one. The key thing here is that all the elements to burglary are here, but they also add the requirement while someone is present. So then it's a more serious offense, home invasion. Okay? And so there's some more. I'm not going to do the rest of them. But those will benefit you in terms of helping you to get ready for the quiz. And then again, please, I know it says as you approach the midpoint, which you are coming to it soon, week 5, and then week 6 actually is the highest point. And then you have 5 more weeks after that. So the quarter goes fast. And so we want to know about your online learning experience. Take the 10-question survey. It should only take you a brief period. Provide us with your honest answers. They're anonymous. I don't know who's giving the answers. But it will help us to be able to provide services. Now, one of the issues that a lot of times students can comment about some of the assignments in the modules, you can do that as well. That's something that leadership sees. And if I see something that continuously comes from students as a whole, I will bring it to their attention as well. Okay? So that's that. So now I'm going to stop sharing here. And so now I'm going to go right into the actual lecture. Okay. And I like to do full screen because it helps to make it easier for you to see it. Okay. So, all righty. Let's see if that's going to work. Sometimes full screen does not always work. Okay, let's go. Yeah, it doesn't. Okay, so let's go back to return it back to, okay, make it bigger. It's too big. Some of these little things here. Okay, let's go back. Trying to get the modules, get it to fit back in there. There we go. Okay, so anyway, offenses against persons. So let's talk about this. Assaultive offenses. Now remember, these are against individuals, not property. Usually states pass the laws. Each jurisdiction has different laws. At common law, assault and battery were misdemeanors under common law. So what's the difference in assault and battery? Well, first of all, assault, and usually they run the two together. Assault usually precedes a battery. Sometimes assault doesn't happen, but the battery can happen. But the assault is actually an expression of an intention to hit that person or touch that person or do something. Like a common assault is to raise your hand or something like that to threaten to hit somebody or use some kind of weapon or something. But then the battery is actually when you touch them, you make contact. So they were misdemeanors at common law. And so in today's law, the simple assault and battery still are misdemeanors. However, depending on the position, like if you assault or commit a battery against a public officer, these are considered as felonies. Law enforcement officers, first responders, individual utility people, postal workers, delivery people, those kinds of things. Even though delivery people are considered as private, but the point of the matter is that their role, aggravated assault and aggravated battery are also felonies. That's when you actually assault someone with a weapon, something that could possibly cause injury to that individual. Now, if you raise a piece of paper, you know, that may not necessarily be assault, but if you raise a whole ream of paper, that's heavier. Then if you get the aggravated battery is when you make contact with them, with those items. So it just simply says what I just said, attempt to inflict bodily harm is assault. Aggravated assault is with a dangerous weapon or with intent to commit a felony. Battery is unlawful touching of another that entails some injury or offensive touching. What is offensive touching? Offensive touching is not necessarily just an accidental bump, but if it's an intentional. Remember, the key thing, it has to involve some mental state, some intentional desire to make contact with that individual. And sometimes hugs are considered as battery in situations if someone doesn't want to hug and then you hug them anyway. Those kind of things. Kisses, same kind of thing. Handshakes, they're different because usually handshakes involve people wanting to. But the bottom line is that, look at it this way, is that striking a person generally is the realm of battery. A battery, aggravated battery, is use of an instrument to create bodily harm. Okay. Assault, as I said, just summing it up, doesn't require any physical touching, such as shooting and missing the person, threatening someone. Aggravated factors involve deadly weapon or something that could induce great bodily harm. Battery requires physical contact with the victim, hitting or pushing, offensive touching, using excessive force to break up a fight, intentional tripping of a person. Intentional tripping. Think about that. Using excessive force in disciplining a child as well. In many jurisdictions is enforced as battery. Great bodily harm, it depends, but it's almost like this. Most people can recognize with their common sense what's great bodily harm. So here's an example here that they posit a question which involves possible great bodily harm, or is it considered as child abuse? So the question is, at what point does spanking a child? Do you take corporal punishment out of the hands of the parent? I think that's a bad move. But California law has a statute that says child abuse is the willful infliction of cruel or inhumane corporal punishment or any injury that results in a traumatic condition. So you traumatize that child. Now, here's a scenario they give you, and you make a decision on it. This kid threw his breakfast at his mother because he was unhappy that they weren't going to Disneyland. The mother puts him in timeout, but he continues to act up, hitting his mom and spitting at her. His mom wants to give him a spanking on his butt, but misses and hits his head instead. Timmy falls over and hits his head on the floor. The doctor diagnoses it as a concussion. Did the mom cross the line? I would say not, because it was an accident and what she did. And, you know, the key thing that most jurisdictions want to do in terms of protecting children is look at all the surrounding circumstances and situations. Of course, though, put yourself in the position as you're a judge or an attorney of your child doing what this child did. I'd knock my kid out seriously, and I'm saying it right here. Not knock them out in terms of give them a blow to punch them. I'd whoop their butt. I would let them know that. But if they were older and bigger than me, then I'd knock them out. Okay. Prosecution and defenses. Simple assault and battery. Prosecutors just have to prove the act and general intent. Just the general intent. In other words, that you knew what you were doing. The aggravated assault have to provide specific intent. That is, that you also understood that the goal of yours was to provide or give that individual some threats or concerns about their life or the ability to be able to receive great bodily injury. So, and it says here, do great bodily harm or to commit a specific felony. That goes into aggravated assault and battery. So what are some defenses? Statutory laws define the degree of force that can be used against teachers, police. That's another public individual. I forgot. I left out teachers. So the question of defenses is, I didn't intend it. Like the one in the situation with the child. Or was the action reasonable under the circumstances? Or was that individual exercising self-defense? These are all possible defenses that can be raised when allegations are made of a person committing a battery or assault. Mayhem, you don't really hear a whole lot of that. It consists of willfully, maliciously injuring another so as to render that person less able fighting. And in many instances, pouring acid or hot water on something. Some statutes include disfigurement. That's what I was talking about. Prosecutors typically just have to prove general intent. Most of the crimes that fall under mayhem now are included under aggravated murder and attempted murder because we've raised it to the level that it's very serious and that you are trying to take that person's life in your actions. Hazing, everybody knows about hazing, and you know, hazing is very, 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 very prevalent now, unfortunately. When I was coming up, we didn't have such a thing, but it says it's the intentional or reckless physical or mental harassment, abuse, often as part of initiation for a sorority or fraternity, some kind of club or something. And so, and usually it involves some foolish pranks, but often can result in serious injury. Many colleges and universities have prohibitions against hazing. I remember when I was in college, we had an organization called J150. Now, this kind of doesn't hit hazing, but it hits something that can hurt an individual. And what the individuals had to do was to ingest so much alcohol within a certain period of time. And what happened is that the organization was broken up because a student drank so much alcohol that his brain swelled, went into a coma, coma, and then when he came out, he never came out, and then he died. Well, that ended it because it was very serious. So those kind of things, little initiation things that are hazardous and dangerous, they don't allow that, and it's actually a violation of the law in many jurisdictions. And these are some examples of hazing. Stalking. Stalking is something that is a protection for individuals who feel uncomfortable about people who are surveilling them or maybe threatening that person with bodily harm or sexual assault, confinement or constraint, or placing that person in a position where they feel that they could be hurt or either killed. And then it gives some statistics here about stalking. 3.4 million persons 18 years or older were victims of stalking. In 1990, California was the first state to make stalking a crime. One of the reasons for that is because the entertainers are out there, and people like David Letterman, some other individuals were stalked by people, and so that was why California was on the cutting edge of passing a stalking law. And then it was amended under federal law, the part of the Violence Against Women Act in 2000, to include stalking as well. Because what happened is a lot of boyfriend or people who had a desire to date someone, or either husbands who were separated or either divorced were doing that. So to protect women, it kind of became a part of domestic violence, so to speak, when it came with husbands and wives or partners, things of that nature, or ex-partners. During the 1990s, a number of defendants said stalking violated their First Amendment right. Courts said no. I mean, what First Amendment right are you're trying to protect? I can watch them, I can see them. Well, the point of the matter is that you have a technique that you put together that's formulated to irritate or make that person feel uncomfortable. That's not a First Amendment right, because now you're infringing upon someone else's right to liberty, okay? Freedom to be left alone. Now we got this new thing, cyber stalking, because of the WWW, World Wide Web. And so now in many jurisdictions, including Illinois, cyber stalking is a felony. And so what harassing, and dealing with Facebook and all the social medias that are involved, Snapchat, Instagram, not so much with LinkedIn. I've never really run across it there, but usually the main place that you'll run across that is Facebook. But you'll also run across it in texting, and even you can do it with emails. So, so anyway, several other states other than Illinois, amended their statutory definition of stalking to include cyber stalking. We're moving up into the digital age and making sure that we protect people there. Rape and sexual assault. Now, forcible rape is, of course, sexual intercourse where a person is forced to have sexual act with a person they don't desire to. Statutory rape is what we call a strict liability offense. In other words, it doesn't matter whether you thought that the person was older than they really appeared. The only thing that the prosecution has to prove is based upon their jurisdiction. For example, let's say if it's 14 years, and that 14-year-olds, and you know and I know that many teenagers now are maturing extremely fast, and that's on males and females. And so as a result, just your observation of them doesn't help you. And so statutory rape protects them because they can't even give consent if they said it's okay or they were a willing party. But if you were an adult and you engaged in it, then you found yourself with a strict liability offense. The law on the books applied whether you knew or not. The matter exception remained valid in England until 1991, where a person can also be charged as an aider or abettor if they assisted another person to rape their spouse. But let's go, oops, I skipped one. Let's go back. Okay, now again, let's take a closer look at statutory rape laws to protect young women. Now it's young men too. It's not just young women from sexual intercourse. And the ages vary from 16 to 18. And as I said, force and consent are irrelevant. Strict liability offense. Consent is also irrelevant. Again, there's also considerable opposition by some to statutory rape because they say the laws are out of touch with our present-day sexual mores. The deal is this. We don't care about your mores sexually. We want to protect the tender age minors from sex until they become adults. Some says it deprive women in their late teens of exercising personal choice. You know what? I have 6 daughters, and my daughters were taught very clearly about abstinence. They were taught to save sex for marriage. Some didn't hear us, but the point of the matter is that while they were minors living in my house, it would be a problem. It'd be a problem. So when you're talking about a choice, you have a choice, all right. The rules of the house are what obey. It depends on how you're raised. But the law doesn't care about that. That's my point, is that the law says this is how we're going to do it across the board. Rape laws have become gender neutral, that's what I was saying a few minutes ago, criminalizing forcible sex between spouses. Now, let me explain that to you. In situations where there's individuals who are married, generally there's no interference unless, for example, some form of sex that may be demeaning to that individual that that person is forced to engage in, or if spouses are separated, and the argument is that what if they're not legally separated? Well, the key thing is that if they're living in separate abodes, probably there could be some debates and arguments that they don't intend to have sexual arrangements. Of course, though, again, it's a gray area and it's determined on a case-by-case basis. Expand the definition of rape to include foreign objects, as I've stated a minute ago, dividing the offense of sexual battery into different classifications. And then finally, which impacts your assignment for this week, rape shield laws. Now, statutes that protect, and this is what rape shield laws were intended to do. Protect the identity of a rape victim and or prevent disclosure of a victim's sexual history. What used to happen is that individuals who were victims of rape, one of the questions that could be asked in court was your past sex history. And so the rape shield laws were created to take that out and say that it had nothing to do with the instant charge there. And so it made a lot of sense. You should be aware that, and I didn't do a lot of rape cases. I did only one really, and that was an ex-boyfriend of a lady who brought rape charges against him. When he decided to go back to his wife, she cried rape, and then I represented him in a bench trial before a female judge, and she found him not guilty, and then, you know, kind of read the Riot Act, Judge Judy for him to the person who was bringing the charges. Anyway, the point of the matter is that the rape laws protect that individual, because what happened is that in most of those cases, the individuals, first of all, rape is a crime when the victim feels embarrassed. It's an embarrassing thing for them. And so as a result, what the defense would do is to bring the individuals to a point where they would just not appear to be credible on the stand. And then the other part was that people wouldn't report rape because they knew what they were going to have to go through if they were going to have a successful prosecution. So they tried to humanize it as much as possible. But the identity of rape victims, you a lot of times see they'll use a doe in there instead of their actual name. And then the rape shield laws have a section in there that required, and I'm going to go over it a little more, as I said already this, and try to encourage people to testify. And so it has nothing to do, the theory is that the victim's prior sexual activity is irrelevant. And so victims of rape should receive no more scrutiny than other victims, and women are not required to resist. That's another part. One of the questions was asked, did you resist? And that was a question. How did you feel during the rape? Those were questions that were asked. I mean, it was demeaning to the individual. So rape shield laws changed that. And then another aspect of rape shield laws that came before I talk about this just briefly is that there are situations where information is brought before the court in camera. In camera very simply means in the privacy of the judge's chambers, out of the jury's hearing. Of course, so it couldn't be out of the trier of fact because the judge is a trier of fact, but it's out of the public's eye and it's private and it's information that's utilized simply to determine how to humanize the process that for the victim that goes through. So we get to sodomy. And sodomy is oral or anal sex between persons and between person and animal. Well, if it's consensual, there's not a problem with it. If it's unconsensual, it's a crime, and it's rape in itself. But consensual sodomy is not a crime in the United States, and it's held that states may not prohibit consensual sodomy between same-sex partners. Well, of course not. With the law being in the state that it is now, the LGBT community and the rights that were established by the Supreme Court and the right to get married and all of those kind of things to each other, there's a lot of things that change. So sodomy would not apply in these situations. Sex offender registration laws. Are they good or are they bad? I think that they're good because of the fact that there is a propensity in individuals who are sex offenders to be recidivists. And one of the reasons that they're recidivists is because there's some emotional or mental issues that cause that individual to, even if they serve their time, to come back out and to find themselves in situations where they will begin to pick up where they left off. And so because of that, to protect the public, registration laws were implemented. Now, some people said that that's unfair to the individual. So there's a balance between if you commit a sexual offense and you have people living in the community who have children, there are females, and then there are males, people, period, who don't want to be around people who are sex offenders, then the law says that you should know who is in your community. So in 1994, there was Megan's Law that required that when an offender was released, they had to register. And the information is publicly available. Here in Illinois, the state police have a website that you can find that information all the way up to your address and zip code. I remember we were going to buy a house a few years ago, and when we discovered that on the block, literally a couple doors down, were two individuals who were charged with being sex offenders and the offenses that they committed. Now, some people carry this a little too far, and this is what I'm going to talk about, where individuals are labeled as sex offenders if they involve themselves in public urinating. Let's say a person has to go and they can't help it, and they, in a park, not trying to expose themselves, but there are people who in some jurisdictions have been labeled as sex offenders because of that, and that's unfair. Those kind of situations. Now, if you're going around flashing and stuff like that purposely and all that, that's another scenario. But again, we get to the point that there's some stuff happening up here. So anyway, the debate continues. Laws punish people based on status. So it says, so now these people are, it's not really punishing them. It's letting people know. Well, let me say this. Isn't it true that if you commit a felony and you apply for either a student loan, or either you're going to apply for a job, or live in a certain community, in an apartment, in those situations, that background checks are done, and certain individuals are not allowed. Well, this is the same idea. And so people who object to that is not based on status. It's based on the protection of the individuals who reside there. People should have people in their communities that they don't feel uncomfortable around, not because of their race, their sex, their religion, or national origin, but because of their propensity to commit certain kind of crime or have demonstrated a history of being a criminal. So this is a case that involved 2003, Smith versus Doe. Remember when I told you how they put the names there? Maybe it says that Alaska Sex Offender Registration Act can be applied retrospectively to defendants who were convicted prior to the act. Well, these people had challenged the statute, saying that the statute was punitive in nature and cannot be applied retrospectively. The court says that the sex offender registrations are not punitive, which I said they were not, and that they're not designed to punish, but they're for the protection of the public, and that's the key. That's the key. And then they give some examples of sex offender registration laws and so forth, okay? So I'm not going to go into those details. Child abuse. It's something that has come about more and more in this time, and basically it's when parents overreact in terms of their children, and usually it involves some kind of battery. Sometimes it's neglect. Neglect can come in several forms. And neglect can come, for example, in not providing the necessities of the child in terms of feeding them, for the nourishment. There was an argument that if you continue to feed your children junk food on a regular basis, should that be classified as neglect? And there are arguments about that. But anyway, the point of the matter is that feeding them no food is clearly neglect. The clothing is dirty, stinky, and it's not, very clean. There's no hygiene involved of them. But because the children have to have someone to protect them, it involves strict liability crimes. So the younger the child, the more likely, if you fail to do some of those things I talked about, the more likely you will be charged with child abuse. And they're mostly misdemeanors. But the effect that it generally has is that the children are generally taken away and either put with another family member or become foster children and are placed in foster homes. And some ultimately end up being adopted. Statutes require medical professionals and social workers to report instances of suspected child abuse. Those are what we call mandated reporters. By law, we are, even as a professor, if I appear to see a trend like that, then I'd have to report that to the proper authorities on my campus, and then it's followed off from there. Now, since we're online, it's hard to do that. However, though, because we do still have events on our campuses where people come to the campus and they oftentimes bring their children, and sometimes parents bring children to the campuses to study with them, if we observe something that appears to fit the form of physically, mentally, or emotionally endangering that child, we have the responsibility to report that individual, not to the authorities, but to our process that we have within our school. So anyway, there's also controversial issues over the question of whether drug use by the mother constitutes child abuse. And oftentimes what happens is that the children are taken away and they're placed in foster care and sometimes adopted, because that child is placed in harm's way. And it's not just the use of the person of the drug, not that the kids get to it, but you also need to be aware as law enforcement individuals and in criminal justice that the unsavory characters that they deal with can create situations that put those children or individuals in harm's way. I can tell you all too often I've seen crimes that happen and people are killed execution style, and I've seen situations where even the little babies were brutally murdered, and it has something to do with the person either using drugs, didn't pay, or something along those lines, or either they're in the business of dealing with it and someone wants to take them out and kill them, so they'll kill all the witnesses and children. So my point is that a person who subjects their child to that is also putting them in risk and harm's way. Spousal abuse, domestic violence, physical, emotional, sexual abuse of one's husband and wife. Courts can issue now what we call protective orders, but I remind people all the time, papers do not protect people. People have to protect people. People have to do the smart thing and the wise thing. I've already shared with you my story about growing up around that kind of stuff, and I am totally in favor of the domestic violence acts that exist in most jurisdictions to protect children, seniors, and also spouses or civil partners now. On the federal level, there's what's called the Violent Crime and Law Enforcement Act of 1994, in which if you take a person across state lines for involving domestic violence, and this kind of like fits with what happened in my scenario with my mother. It says Christopher Bailey was convicted of kidnapping and interstate domestic violence for assaulting his wife and driving her around West Virginia and Kentucky. So he crossed state lines. Well, when my mother was killed, she was assaulted by the man who killed her in Indiana, and her body was driven to Illinois, where she actually bled to death. And so as a result, if this had been in existence, which it wasn't, that was in 1963. But the point of the matter is that when you get into interstate and crossing state lines, that's when the feds can come in. If it's intrastate, the feds can't really come in unless invited in by the authorities. Elderly abuse, same thing as well. There's a lot of that. In Illinois, it's a felony to intentionally or recklessly cause injury to a vulnerable elderly person. And the reason is the same rationale that goes with minors as well. Here's an example here of a person whose uncle was brought to the hospital. Hospital staff observed that he had not had food in a week, was covered in urine and dried feces, and laid in a fetal position that took at least 2 weeks to develop, and they were convicted of elderly abuse. So probably what happened then is the mandated reporter system required bringing it to the authorities. The authorities took that in and then ended up in arrest and successful prosecution of those individuals. False imprisonment is not being in jail and then later on find out you didn't do it, because that would be a lot of people. False imprisonment is the crime of unlawfully restraining a person, and not all states have statutes that make false imprisonment a crime. Most states classify it as a misdemeanor. Some scenarios, such as unlawful arrest by police officers, debatable, depends on all the circumstances. Remember now, these are case-by-case basis. Prison wardens fail to release an inmate. Now, that could be in a situation where you legally were entitled to go, but you're held longer. And we get into that situation. There's an issue about shoplifters without a basis for such suspicion can bring back suits at false imprisonment. An overzealous male does not allow their female companion to leave the apartment without yielding to sexual demands. Again, it's really neutral in terms of gender now. So you can substitute male/female does not allow their companion or partner or spouse to leave the apartment without yielding to their instead of his sexual demands. Kidnapping, abduction, forcible carrying away against that person's will. It's a serious felony, and there are two classifications: simple kidnapping, and usually what happens is that you'll discover that usually simple kidnapping most times will involve some issues of domestic, and that is that a parent of a child, whether they're married in a paternity issue or either going through a divorce or whatever, and children are taken away by one parent or the other. We hear those instances all the time. Kidnapping for ransom, that's, if a person is kidnapped because the family has some wealth and they want to get some money off of that, that's serious as well. Carrying away property of another, asportation. I'm not going to spend a lot of time on that because we're talking about persons primarily. The Federal Kidnapping Act involves taking like Lindbergh baby kidnapping, where a baby is taken across state lines, those kind of things, or a person is taken across state lines. Hostage taking, same kind of thing. Now, you can have that in a bank or in a federal institution. What are some defenses that people use? They didn't really move the person, and the person consented. Kind of hard to say that a person consents to kidnapping. It's generally not a defense, okay? And so it's not like, oh yeah, that's a defense that we can use. You have to sit back and think about all the surrounding circumstances before you reach that conclusion. Child snatching, we already talked about that a few minutes ago. Civil rights offenses are protected by the federal and state, which aims at preventing discrimination. In other words, protect individuals from being injured by public officials, law enforcement, other individuals, teachers, acting under authority of the government, and conspiracy against rights, depriving people of rights under color of law. Whenever you hear that under color of law, it doesn't mean color as you might think. What it means is operating and using their office as a basis. For example, a judge requiring sexual favors for a person in a divorce case or in any other kind of case, or either taking that individual and threatening them if they don't do certain things, those kind of things. But usually the civil rights violations come when there's excessive force used in either arrest or an apprehension or those kind of things. Of course, those civil rights violations can also occur in situations like the person who was possibly drug off that United Airlines plane, those kind of situations. But the bottom line is that it usually involves some excessive force that took place. Wrongful death kind of things where government officials are involved. And then this is an example. Okay, here's a good example. U.S. Supreme Court upheld the conviction of this judge for threatening a woman to deny a child custody in order to extort sexual favors. That's what I was talking about a few minutes ago. Hate crimes, where a crime is committed against an individual, and it could be a crime that's battery, or either aggravated battery or aggravated assault, but the crime is committed because of that person's race, their ethnicity, gender, or sexual orientation. And it could be offensive against property and persons. But the Hate Crime Prevention Act eliminated the requirement that the victim be engaging in a federally protected activity. So the bottom line is that in most state courts, the criminal acts or penalties are enhanced when it is determined that it is a hate crime. You hear that all the time, okay? And so that's it for this one. We have about 30 minutes left, so we're going to go over the next section, the property crimes. So we're now talking about shifting from individuals. Now, be aware of this, and this is what I try. As a defense attorney, prosecutor, police officer, I always remind people that what's most important, property or persons? Well, we already should know the answer to that is that it should be persons, because life is very important. You can only get one of those. Stuff can be replaced. So now we're shifting into the stuff things, your property issues. So at common law, theft offenses were described as larceny, depriving that person of their property, basically taking it away. Wrongs concerning person's land, gave civil and not criminal actions, so that's the way it is even today. Larceny, though, applies mostly to tools, household items, domestic animals, and that particular thing. So now you don't really hear larceny. we don't use that term. We use theft. And we're going to talk about the difference between theft, robbery, and burglary. Again, if you listen to these lectures, it helps you with your assignments. False pretenses, obtaining money or property through misrepresentation, been around since 1757. Embezzlement, of course, when you're in a position of trust and you convert that money to your own use to benefit yourself when that money was intended for the individual that you were trustee over, then a prosecution just has to prove the accused intended to defraud that person. Not use it for the benefit of that person, the way that that person sometimes might want to have it used, but is not fattening themselves. So, if it's providing like food, shelter, or clothing, then that's a different scenario for them as well. Receiving stolen property is also another form of that. That's a common law. But in modern offenses now, theft, as I said earlier, includes larceny, theft of vehicles, shoplifting, looting, carjacking, and extortion. And then on the federal level, whenever you see 18 United States Code, USC, this is the statutory section of the federal criminal law, the federal criminal law, not the state. And when it says A, it's for annotated, which means that statute is given in this section, 18 U.S.C. section 641, but is annotated because under that there are cases that relate to this particular statute or decisions that affected by this statute. Anyway, it takes a crime so kindred as to belong into one category, embezzlement, theft, receiving stolen goods. And then 659 provided penalties for committing these acts as well. And then this is a little chart. I'm not going to go through that. The modern approach, though, to theft is that all states now include tangible and intangible property under definition of larceny. Newer statutes include other crimes besides theft and impose penalties based on the amount and character of the stolen property. Grand theft is the most serious property. Again, a felony, the higher the value. Petty theft is a serious misdemeanor. Again, it depends on the value of that property, the probable dollar amount or sentimental value of something that's less even could be considered as grand theft. Intent to deprive, in other words, it must be an intention of the person to take the goods or services from another without permission or authority of law. And the idea is generally to do it permanently. Now, let's say, for example, a person takes something and he says, well, I was going to return it. Well, that doesn't necessarily apply because the intent that takes place at the time of the offense is what actually applies, and the action matches the intent if you take it. Another form is, for example, if you, rent or lease a car or either a trailer or something like that from one of these companies, and you keep it beyond the period that you do, that then after that it's considered technically as theft because you went beyond the period of time that permission was granted to you for use of that item. Embezzlement, there's some serious embezzlement. This guy, Bernard Madoff, ran what we call a Ponzi scheme. A Ponzi scheme is something that to get you to invest and put your money in that they know doesn't even exist, and to lie to you outright. In the early 70s, 1970s, investors lost $18 billion. And then there were many middle class who lost their entire savings. Well, he was convicted of 11 federal felonies and sentenced to 150 years in prison. And so it's a very serious type of thing. We had something like that too within Enron. You may remember Enron, where there was some pumping up of the value of the stock knowingly for the benefit of those individuals. It wasn't the same thing as a Ponzi because there did exist those things, but they misstated the value of their stock. Here, Ponzi means there was no such thing. For example, like giving you a picture of a real estate development, and it gives you the location of it, then you go there and you find out that it's swampland. That's Ponzi. Robbery. Now, let's break this down. Robbery. What is robbery? Robbery is very simply, notice the elements, taking money or property from a person against that person's will by means of force or intimidation. Notice what it says, taking property or money from a person, from that individual, not where they live or any of those things, against that person's will by means of force or intimidation. You have some weapon or something that holds them in abeyance. Under common law, robbery was aggravated form of larceny, but we don't operate that way anymore. Force or violence have to happen. Force or violence have to happen before or at the same time as the taking. So again, the fact of the matter is that person has to be intimidated or force or violence when it talks about by means of force. So it must be at the same time. And it is an offense against the person, even though we're talking about property, but it includes assault, or it usually involves assault or battery there, okay? So it's kind of wrapping the other two around. But the key element here is by means of force or intimidation, taking the property from the person. There we go. Robbery has federal laws that include bank robbery. Prosecutors need to only establish general intent. State laws, some have codified the common law, as most have, to classify robbery according to degrees, and then aggravated robbery. But the robbery is still the same. Here's a situation here where the U.S. Supreme Court held that an unloaded gun is a dangerous weapon. Well, how could that be? Reason is the display of the gun puts fear into that person. It's not their job to determine whether or not that's an empty gun or a toy gun. And so this person robbed the bank with an unloaded weapon. He argued that an unloaded weapon was not a dangerous weapon. You can't tell that to the other person. It's not their responsibility. Same kind of thing applies in excessive force situations. I had when I was a police officer, I had a young man who I talked him down, but here's what happened. He pulled a gun on me to try to get me to give up my wallet. Well, I never wore a uniform because I always wore plain clothes because I was in a special category. But at any rate, the point of the matter is that I told him my wallet was inside my jacket, and while I was doing it, I was unbuckling. I had a Glock shoulder holster. Then I came out with it and pulled it on him and told him drop his gun, and he did. Then I told him to kick it over to me. It was a toy. Now, if I had shot him with my gun while he had his in his hand, and then later on they discovered it's a toy, would I have used reasonable force? Absolutely, because of the fact that it's not my call to determine whether or not that was a toy gun or not, because it would instill fear to the average citizen, which also includes law enforcement people as well. Carjacking, now that's a term that's used. We didn't use that term before, but it is simply categorized as taking a vehicle from someone by force, violence, or intimidation. People get out and pump gas. Sometimes they leave their cars running. I don't know why. First of all, you're not supposed to have your car running anyway when you're pumping gas. But secondly, I always take the keys out of my car. Even if someone is in the car, my wife sitting in the passenger side, I still take them out, or either I'd unlock the door. And the reason is because someone could come, jump in the driver's seat, and take all the characters, make them get out down the road and keep going. But in 1992, the Anti-Car Theft Act came about, which makes it a crime to take a vehicle. And what involved there was individuals who were operating in interstate commerce. And then Section 18, Chapter 18 of the United States Code, which I referred to earlier, Section 2119, described carjacking and covered all the offenses relating to carjacking. And carjacking is a general intent offense. Your car wasn't yours, you took it, and that's it. And then here's a statute that affirmed that federal carjacking laws apply to defendants with the conditional intent of harming drivers. So in other words, it's pretty clear that a person takes the car and they threaten an individual or put them in a position where they believe they could be threatened. And so the individual then is guilty of carjacking. In this case, the trial judge instructed the jury that the conditional intent requirement was met as long as the defendant intended to cause death or serious bodily harm. So this person threatened to kill the occupants if they didn't turn over the key. That's clear right there. The difference between robbery and extortion. Robbery is taking the property or person from a person by means of force or intimidation. The property is taken by threat or force without consent as felonious. Taking of the property off the person or immediate presence. Now, some might argue immediate presence is that they were in the vicinity. They could be in the vicinity, they could be returning to the vicinity, but they have to be for the entire process in the immediate area. Requires a general intent. It's very easy to prove. Extortion, obtaining money or property by threats of force or the inducement of fear, also called blackmail. Also called blackmail. And so blackmail. So property is taken by threat of force with consent. With consent. That's extortion. Property does not have to be taken from the victim's person and requires a specific intent. Now, forgery, taking a document and changing it. You know, if it's $10, you turn it to 100. Or either changing grades on a college transcript. Basically, what you're doing is you're misrepresenting what the intent of the person who issued the document is. Under federal law, the prosecution just has to prove the intent to pass bad money, for example, as counterfeit, such as that. Okay. By the way, counterfeiting is just makes an intimidation of something with the intent to deceive, making imitations of coins and currency. Bad move to make Xerox copies of money. It is illegal. Now, here's, we're talking about forgeries. Here's an interesting scenario. In 1983, the popular West German magazine Stern made the shocking announcement that they had 62 handwritten diaries from Hitler. Well, the content of the diaries didn't fit the historical view of his character and actions, which made him look like he was more amiable than had been previously documented. Many who had known Hitler personally were shocked because they experienced firsthand the atrocities by him. So after a few weeks, it was discovered the diaries were forgeries. Well, even though the Stern had asked experts to verify the authenticity of the document, and this is where you get the twist. Unfortunately, the experts compared the diaries to original documents that were also forged. by the same person. So when you take what you believe is an original document, but it's determined that that's forged, then of course when you compare the forged document to that, then you're going to get the same results. So the authenticity must originate from the source that was intended. Yeah, so that's the key there. Okay, moving right along, we got a few more to go. Uttering, we already talked about that. Checks. Worthless checks. Writing a check you know that has nothing, or it's a closed account. Usually those are considered misdemeanors, and offenders usually, in cases where they write a check, they're civil actions, but they can be criminal actions. Often tell customers in stores that there's a fee that they pay for that. But if you don't make them whole after a certain period, they can take it to the authorities and you'll be prosecuted for a misdemeanor. Now, let's talk about burglary, because I already told you about what robbery was, and I indicated that theft was. But the difference between theft and robbery, I already gave you. So now let's talk about what is burglary. Now, burglary says very simply, breaking and entering the dwelling of another. A person is guilty of burglary regardless of lawful entry of the dwelling. For example, intentionally remaining in a department store with intent to commit an offense when the store closes. I had a case like that, a young man who dressed like a ninja. He ended up climbing on top of the stall, the toilet in the store, and then it closed up. It was a Kmart. And then when the store closed, he came out and he attempted to rob the people there. So that was considered as burglary, even though there were people there. So as a result of that, of course, that young man ended up being my client with a silly situation. He tried to get away from the people, jumped through the glass, passed out, and that's how the police got him. Crazy thing. But anyway, just the example of burglary, is intentionally remaining in the store after closure. But let's talk about the primary way that we deal with burglary. Now, first, home invasion, I already talked about that, is armed with a dangerous weapon or persons are present at the time of the break-in. That's when you get to home invasion. And that's the more serious offense because, once again, we're jeopardizing life. Then the possession of burglar tools. And then, before we go to arson, I want to go back to burglary. Now, burglary used to, at common law, say that it was breaking and entering with intent to commit a felony at nighttime. The nighttime requirement was done away with, and so burglary takes place during the day and the night. But here's the deal as far as burglary is concerned. You are guilty of burglary if you break what we call the sacred area. Okay, an example here. If you see something on someone's porch in their private area and you take it, that's burglary. You say, well, I didn't enter the house, but it's still burglary. Or it could be theft, but it depends on how the prosecution wants to classify it. But there's an argument that could go either way. But let's say, what is burglary? Someone left an open window and they have a laptop in the house, sitting right by the window, and you reach in and you grab it, but you don't physically take your whole body in. You have committed burglary because of the fact that burglary, breaking and entering, occurred when you put your hands through that area, and your body, any part or an appendage, let's say you had a stick or something, still committed burglary. That's burglary, clear. Some guys get tricked, some of your students get tricked, into thinking that because a person did not open the window, climb in, that they commit burglary. No, just reaching in, you can be guilty of burglary. And that's what I wanted to clarify. So now arson is intentionally burning someone else's house. Now commonly goes to vehicles, structures, and in many states, proof of damage by smoke or scorching is adequate. All the prosecution has to prove is the intent of that individual, mens rea, that mental desire to. It can be a felony or misdemeanor depending upon the circumstances. I would say if there's people living there, and then you can probably look at felony for sure. And also, if the value of the property is a lot more, then you're going to consider this felony as well. Burning property with the intent to defraud an insurance company, that's arson. A lot of people have found themselves trying to make some money by wanting to get out of a deal, and they will intentionally set the place on fire. Here's an example here of a serial arsonist. Now, this is very interesting. This is almost like a color of law activity where a person hides behind the badge. This person, a former fire captain and arson investigator in California, set a series of fires around LA during the 80s and 90s. And the fires were always started around highways and near arson investigation conventions. He was arrested after police matched a fingerprint of his on the time delay device. He was sentenced to life in prison because he's supposed to be fighting in arsons, but he's committing arson. And again, what created his situation that made it worse was that he was supposed to be helping in terms of arresting or the successful prosecution of arsonists, but he was performing arson, hiding behind his badge. That's what we mean when I say color of law. Malicious mischief, it's just plain old vandalism. Willful destruction of property of another individual. Graffiti, or if your utilities are turned off, you reconnect them. Defenses to property crimes. These are some defenses that people can raise to property crimes, saying it was unintentional, such as taking the wrong jacket, wrong bag, mistake of law concerning the ownership rights. Now, that involves a debate about who owns legal title. Usually, these are not in criminal cases. They end up settled in civil courts. A lack of intent, or an alibi, or insanity. Insanity doesn't work very well in most cases because the law of insanity is not very easily proven. And I've had many cases where we tried to prove insanity based on some actions that appear to be insane, but the tests that are used for insanity were not met. Duress, and then intoxication. Intoxication will depend on whether that's voluntary or involuntary intoxication. And so these are some defenses that are used. There's many others, but these are some of the main ones. Okay, that's it. That's all we have here for this. So we go back to the classroom, and I hope that you will take some time and look at this recording, and because I'll be sending out the archive. So with that, the next lecture is 2 weeks from today. That'll be in May. I think I said it was the 9th. And so with that, I'm going to say good night. It's just about 9:55.